Welcome to BBC World News. We interrupt that programme to take you live to a court in Massachusetts, and you can see there, centre screen, Kevin Spacey, the US actor, appearing there, this court appearance charged with sexually assaulting a teenager in 2016. He's just arrived in the court in the last few moments. Let's put the sound up and give you just a flavour of what is happening now. Proceedings just starting there.
Okay, Mr. Fowler, this complaint charges that in the town of Nantucket on July 8th, 2016, did commit indecent assault and battery on person 14 or over.
Sir, if you're charged with another offense while this matter is open, you can be held for 90 days without bail. Mr. DA, request beyond the bail warning, any?
Beyond the bail warning, Your Honor, the Commonwealth is requesting that Mr. Spacey be ordered to stay away and have no contact with the named victim and his family.
All right, certainly the court will impose those conditions. Anything additional?
No, Judge.
Okay, all right. No requests in terms of movement or staying within the United States, anything?
As required by the court, Judge, and as required by the probation department, our only request specifically is the stay away.
Okay, all right. Well, those will be the conditions then. Sir, you'll meet with probation. You'll sign those conditions. You'll be required to stay away and have no contact, direct or indirect, with the alleged victim. All right. I know there was a motion filed by defense. I had occasion to look at it. Mr. DA, have you had occasion to look at it?
We've reviewed them, yes, Judge.
Okay. You want to be heard on the motion, or?
Briefly, Judge.
Sure.
Regarding the motions to preserve, we agree that anything that is currently in our custody and control, we have to preserve, we will preserve, and we will turn over in discovery.
Sure.
As it relates to the motion to preserve itself, we're suggesting at this point that the scope that is being requested by counsel is overly broad. It's asking for July 7th and July 8th of 2016, but all the way up to the present. We suggest that based on what's been filed, up to the present is overly broad. The affidavits in the motion suggest that Mr. Little and his girlfriend or another individual were texting contemporaneously on the 7th into the 8th. And then it says by providing this other information, we'll likely see that something happened or that he talked about it further. But there's no basis for that information within the motion to preserve. We would suggest that it's a fishing expedition at this point, and that the motion should be narrowed at least to the 7th and 8th of July of 2016.
It's a fair point. Mr. Jackson or Ms. Bolero, I don't know who's going to respond, but feel free.
I'll be happy to respond. Alan Jackson on behalf of Mr. Spacey.
Sure.
Your Honor, I don't believe at this point that we need to talk about the scope. That's something in terms of a subpoena. In other words, what I subpoena or what I serve on those individuals might require a discussion or some litigation about the scope. All I'm asking at this point is that we preserve it. In other words, this is data that we believe is not only potentially exculpatory, but likely exculpatory for Mr. Spacey. I simply don't want to see any of that data deleted, destroyed, even inadvertently, or in other words, in any other way manipulated. I don't think it's a burden at all on the Commonwealth, nor on the two individuals named in the motion, MD and the complaining witness, to simply say, I'm ordering you not to destroy anything, so that Mr. Jackson, Ms. Bolero, the Commonwealth can litigate in front of the court at some point whether or not there is exculpatory information that leads all the way up to today. In other words, all I'm asking for is just to put a bubble around that data so it doesn't get destroyed. I'm not saying I get it yet. I just don't want it destroyed yet.
Further response?
We can only control, Judge, at this point what's in the care, custody, and control of the Commonwealth.
Right.
As far as information that would be contained within the specific service providers of these individual cell phone carriers, well, that's different. We have no control over that, Judge. So we would suggest that as far as the preservation goes, whether it be to the individuals directly or to the providers, that it be limited at this point to the 7th and the 8th until more information can be provided as to why it might likely be exculpatory versus a fishing expedition.
Right. I haven't seen any of the police reports, so I don't know what, except for your affidavit, I don't know what information you base this request upon. I do think that the 7th and 8th, certainly it would be appropriate time span to preserve the evidence, but I understand that even if the motion is allowed, it can be modified down the road and can be tightened up. And so I'm inclined to allow the motion. I don't know that I'm going to do it all the way up until, from the 7th and 8th up. I mean, I may give you maybe 6 months worth of preservation, but I don't know that I'm going to require that everything be preserved. Go ahead.
But certainly at this point, that would be satisfactory. 6 months worth of preservation, I think, is better than nothing, and I'm certainly willing to accommodate the Commonwealth and the court's guidance on that.
So from was it July 7th?
July 7 and 8 of 2016.
Right. Okay.
And 6 months thereafter.
All right. And 6 months thereafter, the motion will be allowed. At least there'll be a requirement that the cell phones and I think the cloud-based
Cloud
and then some passwords, et cetera, that all be preserved. As I say, that's subject to further modification one way or the other, depending upon what is discovered during the course of this matter. So,
Thank you.
all right. We have a further date, gents and ladies that work.
We haven't discussed one yet.
You confer with counsel.
Go ahead.
I think we can come up with a date in just a
Go ahead.
second.
Sure. Sir, you can be seated. You don't need to continue to stand. Thank you.